Hi, everybody. I hope you enjoyed your lunch, but you didn't eat so much that you're going to be snoozing through the next panel discussion because I know it's going to be very interesting. Um, we're going to spend the next hour and a half talking about the legislating of public and private spaces and what it means for women and women's equality. I'm going to tell you a little bit about the reconfiguration of our panel, and then talk a little bit about what brought us to the point where we are today. Today we have three, we hope, panelists. Jacqueline Pitangui, unfortunately, from Brazil, was unable to join us, but Raki Goyal from the Women's Learning Partnership is going to be presenting her comments. She doesn't want to stay up on the stage with us, so she's going to go back down to her seat. But I think if she wants to weigh in during the question and answer session, then I think she will feel comfortable in doing so. We also have Asma Kader from Jordan, who is a long-term women's rights advocate and who has worn many hats in human rights organizations, women's rights organizations, government, and other places, and is going to talk to us a little bit about some international challenges. And then Eleanor Smeal, who is with the Feminist Majority Foundation, we hope will join us before we get to her part of the panel, and if not, we'll just imagine what she might have said and continue the conversation from there. So, with that, I think we'll go ahead and get started. My name is Regan Ralph, and I currently run an organization called the Fund for Global Human Rights. But before I did that, I worked for many years on women's rights issues internationally. And I was really struck by this morning's conversations, both in terms of the processing of so much of the work that was done by women's rights advocates in the past 20 years, and also the thinking about where are we now and how have the challenges changed. And I want to pick up on the point that the former Special Rapporteur on Violence Against Women, Yakin Ertug, made this morning about how 1993, which was the year of the human rights meeting in Vienna, created a new arena for women's struggle in the form of women's rights activists moving into the human rights space. Because I think that is very much informs the conversation that we'll be having this afternoon, because in the process of moving into that space, women's rights advocates also really, I'm too close to the microphone now, aren't I? Women's rights advocates also really changed what that space looked like. And it was in particular with regard to this whole private-public distinction that we'll be talking about a little bit this afternoon. When I started working on women's rights issues internationally in the early 1990s, this was one of the primary prisms through which people talked about women's rights issues. And the idea being, of course, that public life was embodied in the form of the state, the international human rights system, and of course it was dominated by men. Whereas the private sphere, which was largely about the family, was where women spent their time. And when women moved into the human rights space and started talking about women's rights as human rights, they looked at the human rights system and said, there's a problem here, which is that the human rights system accepts these norms, the idea that there is a public space and that's where human rights protections apply, and that's actually not working for women. It's not protecting women's rights in the fullness that it needs to, and we want to challenge that frame because right now all it's doing is perpetuating the oppression of women. And women's rights advocates did a couple of things at that moment. They demanded, and I think won in many cases, recognition that women are actually also in public space. And they may experience it quite differently from men, but they're there, and that needs to be understood and responded to. But to the extent that their rights aren't protected in that public space, that's something that we need to change in terms of the framework. Secondly, women's rights advocates really challenged the whole notion of what privacy means, because for the human rights community, privacy had been about keeping government out of places that it didn't belong. And women's rights advocates said, you know what, it's a little more complicated than that, because in that space, that's often where our rights are violated. So we need the protections and the legal protections that the state can provide in that space. And so women's rights advocates found themselves in this interesting negotiation with human rights advocates where they were actually inviting the state, into places that human rights advocates had fought to keep it out of. But the result of that, or at least one of the results of that, was that women's rights advocates sought, both within a human rights context and outside of it, new ways of protecting their rights, and oftentimes they used legal strategies and litigation and legal reform as a way of creating new definitions for what their activities in public space looked like and how they were protected and what it meant to be in the sphere of the family, and have your rights protected there as well. And that's, I think, what we're going to talk about today, is a little bit the challenge of implementation at that level. What has the experience been, both in national struggles for recognition of women's rights, whether you're challenging violence against women in Brazil, or dealing with the issues of what happens to women in conflict, and then their rights post-conflict, or if you look at the case of the United States and what the struggles for women's equality in this country have looked like. And I really hope Ellie gets here at some point, because I don't think that either of the three of us is going to be ready to talk about that. But I want to give you one very specific example from my current work that I think sort of captures a little bit of the challenge and the opportunities that we're talking about this afternoon. We fund a number of women's rights organizations that work in the Congo on violence against women. And one of the challenges that women have in dealing with violence against women, whether it happens in a conflict context or a post-conflict context, and I think the women there would argue that it's a trajectory. It's not, what happens to women in conflict is not, in the Congo, is not a aberration. It's a form of abuse that's on a spectrum of the things that women suffer because of their secondary status in many cases in that country. And one of the things that the women's rights advocates there are doing is challenging the norms that prevail in peacetime, in the hopes that that will do something to challenge the way women are treated in times of violent conflict. And when they started looking at that, they were looking at issues of justice and how do women have access to justice, and what can they do to challenge abuses against them when they occur. Now, the Congo actually has some pretty good legal protections at the national level. So the first thing you think is, well, let's enforce the laws that are available to us at the national level. The problem in a country like the Congo is the vast majority of women have no access to any formal justice mechanism. Mostly what they have access to are customary dispute resolution mechanisms, customary courts for shorthand. And what they found was they monitored the disposition of cases that women were involved with in customary courts, and found that, this was several years ago, found that about 80% of the time those cases were resolved by local authority figures in the community in ways that was inconsistent with women's rights and inconsistent with the protections of women's rights that can be found in national law. 80% of the cases were defying legal protections for women's rights. So they started a campaign of not only calling out what their rights are and demanding that they have their rights, but working with the figures who predominate in customary law application, the local elders and things like that, to educate them on what the standards are and how women's rights could be better served by the way that they resolve their claims. And they worked with them across the board in different cases, basically engaging them in as constructive a fashion as they possibly could. Less than 10 years later, they did a similar survey to assess what was the difference that their educational efforts were making. And what they found was that now in only 10% of the cases that they were monitoring were the decisions made in a way that was inconsistent with women's rights and national legal protections. That's an incredible change over a relatively short period of time, and it has huge meaning for those women we were talking about this morning at the community level, who are looking for ways to articulate their need to be able to protect themselves, their children, and take care of their families. And that, I think, tells us something about what kind of challenges we're up against when it comes to implementation, but also what the opportunities are.